Today we explore wrongful conviction compensation laws. Town and Green were wrongfully convicted following the Wenatchee sex raid. They served 6 years and 5 years, respectively. Years later, statute was implemented permitting compensation for wrongful convictions. Town and Green sought compensation but were denied. Now it's being argued at the Court of Appeals. Let's check it out.
Doris M. Green and Meredith Town versus State of Washington. Counsel for the appellant is Mr. Owens. Mr. Owens, if you could begin by letting us know how much time you would like for rebuttal.
I'd like 5 minutes for rebuttal, please.
Thank you. Please begin.
May it please the court, David B. Owens on behalf of Doris Green and Jean Town, who, like many others, were victims of the 1995 Wenatchee sex ring fiasco and wrongfully convicted of crimes they did not commit. Their convictions were overturned in 2000, over a decade before enactment of the Wrongfully Convicted Persons Act in 2013. Green and Town are actually innocent and are entitled to proceed with their claims. However, at the state's invitation, the trial court took the extreme step of dismissing both claims with prejudice after finding their submissions deficient under 040, which requires at filing a claim be established with documentary evidence. This unique rule indicates that actions under the WCPA are special proceedings under Civil Rule 81 and should be treated that way. At the same time, there is uncertainty about what a claimant must do to satisfy this documentary evidence requirement. And there is uncertainty about what it means to, quote, establish something at the filing stage by documentary evidence under the Act. This court should hold, as a matter of first impression, the documentary evidence includes a wide range of materials, not only court filings and public documents, but also affidavits, declarations, and other sworn statements.
Mr. Owens, can we
yes,
break down the statute a little bit on that? Because the statute says in order to file, you have to do certain things, and it distinguishes documentary evidence from the things that you have to do in addition, which is a statement. So it seems like the legislature is contemplating something beyond just a statement by the claimant in order to satisfy documentary evidence. Why is that incorrect, or is that correct?
I agree, Your Honor, that the legislature and the distinction that you've identified between 040(1) and then 040(2) does create a difference there. The question, I think, is what it means to establish something by documentary evidence, and whether or not, for example, that could be done by pointing to something through judicial notice, or whether or not it can be done through other means. The legislature did not, as we pointed out in our brief, use the word attach or something like that. And so I don't think for one, the legislature and the WCPA did not define what it means by establish something by documentary evidence, and it did not define what it means to establish something by that. So I do think that.
Was there judicial notice that would include, if the judge could take it into account, okay, these cases were dismissed, but there's other things that the documentary evidence must show, that the claimant's not currently incarcerated for any offense, that the claimant is during the time period of confinement, they were not serving a sentence for any other crime. It seems like it goes beyond just, okay, yes, this person was convicted and then pardoned, or they had the conviction reversed. So why is there judicial notice as to all those separate elements of documentary evidence?
I think that there could be some, depending on the circumstances. It depends on what a petitioner is able to point to. So, for example, in this particular case, as we pointed out extensively in the opening brief, there are, a number of judicial proceedings that indicate that for both Green and Town, the basis for their wrongful conviction that we think shows that it was turned over or overturned on the basis of exculpatory evidence, that the judicial decisions define go into the fact that how the convictions were obtained as part of this fiasco that I've described, and also that illustrate, I think that that there was a prior felony conviction, as the court pointed out. And I think ultimately, the question for this court comes down to, with respect to whatever it means to quote unquote establish something by documentary evidence, and whether or not that can be done by judicial notice. The fundamental problem with the trial court's ruling is that the trial court did not allow the claimants the opportunity to supply additional documentary evidence after it issued its ruling, saying that whatever you've submitted to me, even if by judicial notice, even if I reject your verification argument, that you don't have another opportunity to present that evidence to the court unless you did it correctly at the very, very first time. And
Mr.
so
Owen,
yes,
I've got some questions following up on that point you're making. Typically, a judge will allow a complaint to be amended to cure defects. One reason they don't is because it would not do any good. The question in this case is whether or not the lawsuit would be timely if the trial court allowed you to amend. When reviewing the record, I saw a couple declarations, short declarations from each of your clients talking about their incapacity. And the argument was that each of these people were incapacitated, therefore the statute of limitations were told. With regard to Town, it's very clear that Town had Alzheimer's for a long period of time before she died. It's a she, correct?
no, it's like Eugene Town. That's it.
Okay. I thought I saw. Okay. Well, that Mr. Town then had Alzheimer's, and there's a doctor's declaration. So why did the court not give weight to that?
Well, the court below didn't address this issue at all. So the only issue that the court below addressed was whether or not the documentary evidence standard under 040 had been satisfied. So we think the issue about timeliness or something like that is an issue for factual development, as the court pointed out. It's not something that the court addressed or ruled on in its ruling that has been appealed to.
But it was argued below because there was that declaration, correct?
It was argued below with respect to Town. And the argument below with respect to Green was that there was additional evidence, medical records related to incapacitation and that issue that counsel had become aware of before the argument and sought leave to present to the court. So
counsel was given plenty of time to produce those records, and that's one reason it dragged on for a while. And those records never were produced to substantiate Green's claim of incapacity.
Well, so the record's a little bit different on that issue, Your Honor, which is that there's a declaration from counsel Michael Martin that in the record that said, I learned of new information of incapacitation with respect. I think it was the week before or the lead up to the hearing, and that was or some time before, and that was part of the motion to dismiss response in that.
But that declaration, though, wasn't really, I don't think, admitted for purposes of establishing the truth of the information, but for a request for further continuance, right?
I thought the way that I read it, Your Honor, was that as it relates to this incapacitation and service and timeliness issue, that the declaration said, from counsel, I learned of additional information that I would like to provide to the court if I've been given leave to do so. Now, that issue, I think, is something where the factual record was not developed, and as it relates to that purpose, because I think the court is right, and it's important to, I think, distinguish two things. As a general matter of first impression, what we're saying is this court should hold as generally as it would in a normal civil case. If you amend a complaint or supplement a filing with additional documentary evidence, if that's what this court rules, that would relate back to the time of the filing. Now, there's a separate question about whether or not there are other timeliness issues about the filing, and the trial court here didn't address those issues. And so it's our position, we think, that the trial court is in the best position to address those, and that there is significant factual development as it relates to that issue that would need to be held below. So
in order to relate back, don't you need to actually serve one of the defendants within 90 days of filing the complaint?
well, Your Honor, that is actually an open question about the rules that would apply with respect to service. So section 030 says that service of summons is governed by RCW 4.28.080, which provides the modes of service for all sorts of actors. The framework that we're operating under RCW 4.16.170 versus .190, the tolling provisions that the state has pointed to and we've addressed in our briefing, though that is right, the timeliness issues, whether or not the statute of limitations was told completely, and to what extent and for how long, related to the 90-day service issue, I think is something that has not been explored completely factually. There's a further issue which I think.
Is there an issue of fact that you did actually serve them within 90 days?
I think that there is an issue of fact with respect to whether or not the 90-day requirement applies, and two.
No, that's a legal issue. That's a legal issue.
Sure, correct. But there is an issue of fact with whether or not. I don't think there's a dispute that the state was not served within 90 days. I think there's a factual question about whether or not and the extent of the tolling and the statute of limitations, and as another sort of issue of factual development, the reasons why the state was not served within those 90 days, if that requirement is applicable.
Does the tolling provision apply not just to the statute of limitations, but then once you filed the lawsuit service? Because I just read it as applying to tolling the statute of limitation, which makes sense because once you filed suit, you're represented by an attorney. It makes sense that you're no longer under disability. So then the 90 days would apply.
You're right, Your Honor. I think that there's two things with respect to timeliness about that issue. One relates to whether or not the period of incapacitation extended for these individuals after that, and you could play it out if a court were to say this wasn't properly served and dismissed. Then there's a separate question of whether or not they could refile, and the law is clear that that type of dismissal is not the basis for. And there's a second issue here which didn't come up as much in the briefing, but in anticipating that this might be some of the court's questions, I wanted to make sure that I thought about it, which is the Washington law recognizes, as a general matter, clients are held for, quote unquote, the sort of the sins of their attorneys. However, the courts have recognized in Washington that there are reasons not to hold that rule flex when there's inexcusable neglect by counsel, and there's a decision I can supplement the record with from 2020, which is Richter v. Helinski, 13 Wash App 2D 1058, and in that case, and another Washington State Supreme Court case pointed to therein, the courts recognize that clients should not be punished for the inexcusable neglect of their attorney. Now, that general rule should apply with all the more force here, given the fact that there's this evidence of incapacitation. I see that I've only got 2 minutes left, and I'd like to reserve it.
Thank you. Mr. Liu.
Good morning. May it please the court, my name is Kent Liu, Assistant Attorney General, and I represent the state of Washington. This case involves two plaintiffs who in 2003 recovered compensation for Chelan County for their wrongful convictions. And after having already obtained a remedy, they now seek additional remedy under the Wrongful Conviction Act. The Chelan County Superior Court correctly dismissed plaintiffs' claims, and we ask that this court affirm the trial court's decision. The court had questions for counsel regarding judicial notice, and I'll address that question first. With regard to judicial notice, plaintiffs argue that the court erred in failing to take judicial notice of documents filed in their criminal cases and their personal restraint petition. However, the case law is clear in the state that the courts may not, while trying one case, take judicial notice of records of other independent and separate judicial proceedings, even if they involve the same parties. The problem with plaintiff's arguments regarding judicial notice, in addition to the case law, is this. They never proffered what particular documents they wanted the trial court to take judicial notice of. They never made a showing as to the authenticity of any particular documents. There's no reference to any specific documents in their complaints. Their complaints simply contain conclusory allegations, but nowhere do the plaintiffs reference any particular documents they wanted the trial court to consider. In fact, 2 years after plaintiffs filed their complaint and 5 months after being placed on notice by the state that we are moving to dismiss because you failed to provide documentary evidence, plaintiffs still did not provide any documents or attempt to make any showing to the trial court what they wanted the court to take judicial notice of. In fact, at the motion to dismiss, there was no attempt by plaintiffs to establish what specific documents they wanted the court to take judicial notice of. No attempt.
Yeah, you might be correct that we simply can't take judicial notice, but is there really any contest that the elements in the first part of the statute are met, that there is documentary evidence under subsection 1 of 040, that yes, these plaintiffs were convicted and sentenced to a term of imprisonment, that they're not currently incarcerated, and the other factors? Is there any serious dispute over that?
There is no serious dispute except for the problem that we don't have any documentary evidence of that, which they were required by the clear and plain language of the statute to provide to the court. They were never able to establish that. They
If there
didn't
was a timely amendment, you wouldn't have a problem with that if there was a timely amendment.
Correct.
So the question, I think, really goes to whether there could be a timely amendment. In other words, did the trial court abuse its discretion by not allowing an amendment? And this gets back to the issues that we were discussing earlier about tolling, and Judge Pinnell asked an excellent question about when does tolling stop? Shouldn't it stop once a person incapacitated has an attorney and has filed a lawsuit? Because there's no real purpose to continue the tolling when the person's rights are represented by an attorney. Would you like to address those issues?
Certainly. With regard to tolling, plaintiffs had tentatively commenced this action when they filed their complaints for Mr. Town 2 days prior to statute of limitations deadline, and for Ms. Green 1 day before the deadline. By statute, by court rule, they are required then to serve the state within 90 days of that filing. However, the plaintiffs now claim that, well, they now allege some type of a disability or incapacitation that prevented them from perfecting service. The problem with that argument is the plaintiff's complaints included verifications by both parties attesting under penalty of perjury that their claims in their complaints were true and correct, notwithstanding their purported disabilities, which in their affidavits, they indicated that their disabilities occurred even prior to the filing of the complaint. Yet when it came time to perfecting service of their complaints, they claimed that they were too incapacitated to perfect service, despite being represented by counsel who would normally be the person to perfect service on their behalf. And that's something that's routinely performed by counsel. Plaintiff's explanation for their failure to perfect service for 10 months after filing their claim was clearly inadequate, and the trial court was correct and did not err in dismissing their claims. And I'm sorry, Judge Lawrence Bear, you had another issue that you wanted me to address.
Well, I think you did. I think you explained, maybe not too directly, but you explained that even though they may have been incapacitated, they had counsel who were protecting their interests, at least by the time the complaints were filed. Do you have authority that says that the tolling stops at that point, because the statute itself doesn't seem to distinguish between whether a person's represented or not. It says that during the time that they're incapacitated, the statute's told. And I know that, we have to construe statutes, and if it's clear, we've got to, we can't interpret it, so to speak. We've got to just apply the clear meaning. How do you have any case law that allows us to say that the statute of limitations ceased tolling once the complaint was filed?
I don't, but I can provide supplementary authority to the court if you wish.
I would like both sides to supplement that. I think that's an important issue.
I have myself on mute. Mr. Liu, I'm wondering if it's important that the tolling statute says that at the time of such disability shall not be part of the time limited for commencement of the action, that the statute itself is talking about commencement of actions, not other deadlines once an action is commenced.
That's correct. And that's a distinction there, the commencement of the action versus perfection of service.
Okay.
The case did commence. It was tentatively commenced when the parties filed their complaint. So by technically the case did commence. However, it was tentative because they had to perfect service. So we're actually dealing with that aspect of the case, whether their disability prevented them from perfecting service. And clearly the record is clear that there was nothing to prevent them from doing that. In fact, the record below the verbatim reported proceedings, Mr. Towns, the counsel representing Mr. Town and Ms. Green represented to the trial court that all of the issues, all of the documentation regarding Mr. Town's incapacitation has been presented to the court, and that there was nothing further that they wished to submit to the court. So that record is complete. And the only issue was with regard to Ms. Green, and the counsel for Ms. Green indicated they wish additional time. But nevertheless, they have had plenty of time to produce evidence, in this case, to the trial court. 2 years, if they failed to do so, they had 90 days to perfect service. They didn't do it for 10 months. The record clearly established, and this is really an unusual case, but the record clearly established that they were given plenty of opportunities to follow the procedural rules, and they failed to do so.
Judge Lawrence Berry, your other question, if I recall correctly, was the feasibility of amendment or the possibility of amending. I don't know if you want to address that.
Certainly. Amendment would have been futile under the circumstances in this case. Again, because the plaintiff's claims were time barred, any relation back would have been futile. Statute of limitations had ran already. And the trial court correctly determined that amendment would be untimely. Again, when we look at the timing, when we look at the time that has elapsed in this case, 2 years since the filing of the complaint, and plaintiffs never produced any documentary evidence. 5 months, yes.
Would it have been futile if you determined that the plaintiffs were incapacitated up until the filing of the complaint? Was it that too much time had expired? I mean, if the case had just been dismissed and they refiled based on disability, well, why would amendment be futile if they had a told statute of limitations up until filing based on disability?
If they did have a record and they have produced sufficient evidence that they were disabled and that the statute of limitation told, certainly it wouldn't be futile, but the record developed below did not establish that. And when we look at the trial court's decision was an abuse of discretion, a state would submit that there was the trial court did not abuse its discretion considering the record before it. And again, the timing, the length of amount of time, the opportunities for the plaintiffs to produce evidence and produce a record and establish the evidence of their incapacitation or disability was provided, and they never did. They produced, in fact, again, as I mentioned before, Mr. Town indicated, this is the evidence I have regarding his incapacitation. Here it is. The trial court did not abuse its discretion in considering all that evidence and denying their motion to amend. With regard to the document, well, actually, with regard to whether this court's recent decision in Larson prohibits a additional recovery under the Act, the court's decision is clear. The legislature intended the Wrongful Conviction Act to be an exclusive remedy. Plaintiffs here had already obtained a recovery in 2003 by the Act's clear language, plain terms, and the legislature's clear intent. This Act, remedies under this Act, is meant to be an exclusive remedy. And since plaintiffs had already recovered under their 1983 lawsuits against Chelan County, they are not eligible to recover under this Act. So there are three basis to uphold the trial court's dismissal of the claims in this case, any of which standing alone would allow this court to affirm the trial court's decision. Are there any further questions for the court before I end? Okay. The state respectfully requests that this court affirms the trial court's dismissal of plaintiff's claims. Thank you.
Mr. Owens, your rebuttal.
Thank you, Your Honor. And I wanted to start with the question that you asked Judge Pinnell, because it was what I intended to address as it relates to the timeliness issue, which the section of 4.16.190 says the time of such disability shall not be a part of the time limited for the commencement of the action. So if you assume, play it out, this is sort of what I meant earlier, was that if the plaintiffs were incapacitated, and even if the court were to find that ended at the moment they had counsel who didn't affect timely service, and that was for 10 months, the fact of incapacitation would continue to toll that 3-year statute of limitations. And so,
Mr. Owens, I understand that argument, except that under the Wrongfully Convicted Persons Act of 2017, it provides a certain amount of time for claims that accrued before the act to be filed. And that's where you were within either a few days or a month and a few days of that date. And so it's not as if you get another 3 years beyond that. It looks to me that you get only up to that date given by the statute.
Well, I think that if the court were to find the tolling provision applies, that would apply, I think, with respect to 090 and the Wrongfully Convicted Persons Act to continue to toll that deadline. And I think, just to take a step back, these are all issues that I think need factual development at the trial court. So one of the issues about whether or not service was proper and all of those things, they haven't been fully meted out. And I don't think it's unusual for, when you have a normal civil proceeding, to the defendant files a motion to dismiss and the plaintiff says, we think our claim is fine. And if a court says, hey, come back later, I disagree, it's at that point you usually submit something extra. And under the WCPA, that would be documentary evidence. And there is a dispute, I think, about timeliness with respect to these issues, and it is not the basis that the court below ruled upon. And I think that this court, given the way that the court below ruled, it didn't reach this timeliness issue. What happened, why it happened, why it didn't happen hasn't been determined. There hasn't been a fact-finding hearing about any of these issues as would normally happen in other contexts. And so given that fact, we think that a remand, the court should reverse and remand with instructions to do that fact-finding here. And so we request that relief and that Gene Town and Doris Green, who were well and truly wrongfully convicted, never had the opportunity to avail themselves of this statute, and who have been incapacitated should not be punished in this situation if the court were determined that their counsel made an error or something of that nature. And we thank you for your time.
Thank you, Mr. Owens. Thank you, Mr. Liu. We appreciate your presentations. This matter is submitted and we will take a short recess before our next matter. Thank you.
Following these arguments, the court affirmed the previous decision, but on an alternate ground. Because Town and Green previously received compensation for their wrongful conviction, they were not entitled to compensation under the WCPA. If you like this video, please hit subscribe and let me know what you think about this decision in the comments below.